Work, recognized with an Emmy Award for Outstanding Talk Program for 2 consecutive years. Eat Your Call with Lynn Doyle starts now.
What do you think about the workers who lost their jobs after they refused to take a test to determine if they were smoking? Should a company have the right to dictate to employees what they can and can't do on and off the job? Or is it a great way to keep health insurance and other costs down? Get fired up and tell us what you think about being fired for smoking right now on It's Your Call. Good evening, everyone, and thank you so much for joining us. I'm Lynn Doyle, bringing you another one of those topics that I'm sure will inspire angry phone calls and lots of emails, but it's also one that makes you think and wonder out loud if it might really be a good idea after all. The subject, smoking. Now, most people agree it is bad for you, and many smokers admit they wish they could kick the habit. But this topic has a new twist. It might kill you, but should it get you fired? Well, in Lansing, Michigan, 4 workers have lost their jobs because they refused to take a test to determine if they had been smoking. You see, their employer, Wyco, a healthcare company that has a policy in place that says it prohibits smoking not only in the workplace but everywhere else, they actually told the smokers, work, smoke free, or lose your job. Their logic? Well, smokers cost way more in healthcare costs, essentially costing the company and other employees lots of money. When the workers refused to take a test that would prove that they violated this policy, they resigned, knowing that they would be terminated. Our question to you, is that fair or not? It's a great debate. So we want to know what you think about it. Should a company have the right to make such a policy? Do you think it's a good idea? And was it within its right to ask those employers or employees to actually quit smoking? Were the workers wrong to agree not to smoke and then go back on the deal? See, I told you it was a good topic. If you want to tell us what you think about this and about the idea in general, go ahead and give me a call. You know how it works. It is toll-free from wherever you are watching. You can also email me or take our web poll at cn8.tv. I can only hope that our printer will be able to handle it all. Our panel this hour can't wait to get into this debate, so let's introduce them right away. Joining us from Flint, Michigan is David Houston. He's a labor and commercial law attorney who represents Wyco Incorporated. Edith Pearce is an employment law attorney. She supports the employees in this case. Craig Green is an assistant professor at Temple University's Beasley School of Law. He agrees with the company's position. And joining us from Boston is Nancy Schlepsky, an employment law attorney. Before we hear from all of them and take your phone calls, though, we want to give you a recap of what's happened at this Michigan-based company. The question is, just how far can an employer go in deciding what is appropriate or not on your own time? Well, Mary Snow tells us more. We ask on this show tonight, how far will it go if companies are allowed to tell you that you can't smoke when you're in your own home or in your car or off duty? If you want to tell us what you think about that premise, feel free to start calling now. I do want to start our discussion tonight with David Houston, who represents Wyco, who's at the center of this controversy. David, it's good to have you with us.
Great, Lynn. Thanks to be here.
What was the response from the majority of the employees when Wyco put this policy in place?
The majority of the response from the employees has been very positive. We had a number of people who had actually come to the company founder before this policy was put into place and complained that their coworkers were taking longer breaks, were coming back from those breaks with an odor about themselves, and just had a concern about those kinds of personal interrelationship issues. Of course, there are employees at the company who then and now have disagreed with the policy, don't feel that it's appropriate for there to be a review of their private private habits or behaviors, but we've gotten a very positive response, and in fact, I think a majority of the workers in the company support the policy.
What about those people who admit they smoke but wanted to go along with the policy? Was there any procedure in place to help them quit smoking?
Another great question. I helped draft a policy for the company. We started off working on this over a year and a half ago. We developed a policy that was announced in October of 2003. At that time, the first phase was we asked workers to self-identify if they wanted to, and we offered programs really any program that the employee wanted to engage in. Smoking cessation programs were offered on and off campus at the company's cost. Patches were provided. We had one woman who used acupuncture and actually claims that that helped her quit. And we had people who used hypnosis. So over the course of the 15 months, employees were on notice that the policy would be effective banning smoking January 1, 2005. And at the end of that 15 months period, approximately 20 employees quit smoking and 4 employees did resign before the tests were administered.
Of course, as you know, this has raised the question, are employers taking this too far by implementing this kind of policy? While many people may agree with you that it's your right to say we don't allow smoking on our campuses or in our buildings, what right do you feel you have to tell people what they can and cannot do when they're not in your employ?
Well, the law is established that the company does have the right to hire employees based upon whatever criteria the company believes are supported by business judgment, as long as there are not illegal criteria that are used. So the illegal criteria that we as a society have agreed upon are, for example, race, age, sex, religion, those kinds of things. In some states there are, as you other commentators will point out, smokers' rights statutes that those state legislatures have passed, but there are no such laws in Michigan, and as far as I know, there are no laws in the states where your other commentators are going to be speaking from. So
I'm sure that you
basically in Michigan, the employer is allowed to do this.
I'm sure that you have heard this question, though, many times in recent weeks. Where do you draw the line? The ACLU representative in our piece asked that question, and I must present it to you. If you say people can't smoke because of the health costs that are associated with that habit, what about drinking? What about driving too fast? What about sitting out in the sun and risking yourself to skin cancer? And what about having children? Certainly that's a health care cost as well. Where do you draw the line?
A good question. I have a lot of answers to that. I'll try to stick to a couple. First of all, lawyers and employers are about line drawing, and lawyers' jobs are to draw lines. And the line that the employer has drawn in this case with the help of the law is that the employer's made a commitment to its employees to improve the healthiness of the workplace. And the employer's drawing that line as far as tobacco smoking. And I have to tell you that's fairly non-controversial, because I don't know anyone anymore who actually does not know that smoking is a serious health risk. With regard to some of those other behaviors, I think that the employer has done a service to the country, because we're having this conversation, and WICO has no aims beyond the smoking cessation other than positively encouraging its workers to become more healthy through other positive policies. But as far as line drawing, this is our line, and we're happy that people are talking about it.
Well, we're going to give our other guests an opportunity to talk about it and see what they think about how far this line should be drawn. Edith, if you can give me your opinion, what's the objection to putting a policy in place that arguably is healthier and safer for everyone involved, smokers included?
Well, it's not just that the policy, it sounds like a good policy. It does. It sounds good. But that's not the basis of the objection. The objection is it's actually an invasion of our right to privacy. It's an invasion of our self-determination, of our being able to make a decision of what we will and will not do for ourselves. And when you look at that slippery slope argument, where do you draw the line? How about riding a motorcycle? Everybody knows that driving a motorcycle is generally more dangerous than driving a car. So should anybody who works for WICO who drives a motorcycle be restricted from doing so because it's a greater risk?
Nancy, Edith used the term slippery slope. Is that what concerns you about this particular issue?
It does. I actually have some additional concerns, and just one thing, I'm from Massachusetts. We actually have a privacy statute that would protect these employees, so I just wanted to be clear on that. I'm also concerned as a discrimination attorney about the disparate impact that this kind of policy has on groups of people who have a higher percentage of smoking. For example, racial and ethnic minorities, also women smoke in a greater percentage. So this kind of policy actually has a disparate impact on those groups.
Craig, your thoughts on this? Are minorities and women being targeted, or is it in fact a way to help these people get motivated to quit?
Yeah, I think there are two really important legal questions, and one of them is whether or not this does constitute some sort of disparate impact claim, whether courts would look at this as trying implicitly to filter out racial groups and women. I think that's really unlikely. It's possible in particular cases, but I don't think there's anything pretextual about this. This is not a mask for something else. It really is a health policy issue. The second legal issue is just straight up the lifestyle choice of smoking and whether it should be protected or not. There are some states where it's protected. There are some states where it's not, and that's a decision for the populace and the politics and the legislature to decide. And I think in a state like Michigan, where they've decided that's not a lifestyle choice that's protected by privacy, it leaves it up to the employer, just like it leaves it up to other private entities in the community to make decisions.
But I think the question is, it's fine for the employer to say, okay, this is what we want when you're on our property. I think where people at home are probably having some question and you know, even those who are non-smokers or support the company's decision, they say, wait a minute, but what I do in the privacy of my own home, who has the right to tell me what I can do and what I can't do?
But it's also a violation of your right of association. What if you decide at night you want to go out to a club or someplace where they smoke? So you are now ingesting secondhand smoke. If you took a test, you probably showed nicotine in your blood. Now, is that person violating that policy just because they have ingested smoke? Maybe they didn't smoke the cigarette themselves, but yet they have that.
David, how would you address that?
Well, that's a great question. Let me go back and make this quick point to Ms. Pearce, who had talked about the right of self-determination. I think that that's a misleading argument because I don't know of anyone who's going to advocate that someone's 23-year-old son who has tattoos all over his face is going to expect or be able to claim as a civil right equal treatment when he comes in and applies for a job at McDonald's. And the right of, you can call it self-determination, but there is not a civil right of smoking. I think that to equate that with any kind of a greater privacy or liberty right is, or civil right is actually, denigrating to people who are really having to live with civil rights issues and having to fight them